State is present. Defense is present. Are there any matters that we need to address before the court imposes a sentence from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Is there any legal reason why this court cannot impose sentence at this time, Mr. Kaczargas?
No, Your Honor.
This court has given this case a tremendous amount of thought, not just today, but in the days and weeks leading up to this sentencing hearing. This is a difficult case. This court has faced several very difficult cases recently, and this one is no different. The defense in this case has filed a motion and requested for this court to depart below the guideline sentence. As previously stated, the minimum sentence based upon the guidelines is 227.25 months in Florida State Prison. In analyzing the defense's motion and request for the court to downward depart, the defense has presented throughout the course of this sentencing hearing evidence and testimony that would meet the preponderance of the evidence that would permit this court to deviate and downward depart. The court does find that the defense has met its burden, showing the defendant's capacity to appreciate the criminal nature of the conduct. He does require some specialized treatment for a mental disorder that is unrelated to substance abuse or addiction or for physical disability, and the defendant is amenable to treatment. I don't know that I agree that this was an unsophisticated manner. I'm not going to find that as to that factor. And I do believe that the defendant is old enough to appreciate the consequences of the offense. So the only factor that the court does find that the defense has met is the fact that he does require some specialized treatment for a mental disorder that is unrelated to substance abuse or addiction or for physical disability. That does not, the analysis of downward departure does not stop at the defense's meeting the threshold and establishing by preponderance of the evidence that there are mitigating circumstances that would permit this court to deviate below that guideline sentence. The second prong of that analysis is whether or not the court should. June 3rd of 2023, the events that unfolded on that afternoon were horrific. This defendant launched a vicious attack on a 17-year-old girl who had done nothing but show him love, and only weeks earlier had done her part to try to save his life when he attempted suicide. The same person that tried to save his life, he violently and viciously attacked. Many folks in this courtroom have declared Kennedy Armstrong a hero. This court has no quarrel with that assessment, Kennedy Armstrong is most certainly a hero. And but for his actions and the actions of Madison's mother, this defendant would have successfully killed Madison Schemitz. That crime, the crime that was described and shown here today, and the result of that crime, and the impact of this crime that it has had on all three of the victims in this case, leads this court to the conclusion that any deviation below the guidelines is inappropriate. So I'm denying the defendant's motion for downward departure. I have considered the mitigating circumstances that have been well presented by the defense in this case. Mr. Kuchergis, you have done an excellent job in representing your client and providing this court with mitigation. And this court has carefully thought and weighed and considered your client's age, his lack of any prior criminal history, the fact that he was suffering from clearly a depressive state of mind when this happened, and his age. This court does not impose a sentence based on vengeance. As was mentioned, that courts are not here to sentence out of vengeance. This court has carefully thought about all of the mitigation in this case. But the crime that was committed the impact that this crime has had on Madison, Jacqueline, and Kennedy it just far outweighs any of the mitigation that this court has considered. There are just certain crimes that are committed that merit the maximum possible sentence. And this court finds that this is one of them. Mr. Pearson, you have entered a plea of guilty to 2 counts of attempted first-degree murder with a weapon. As to counts 1 and 3 of the information, you are adjudicated guilty. You are sentenced to serve the remainder of your life in prison. As to count 5, you are adjudicated guilty. You are sentenced to serve 30 years in Florida State Prison. All sentences are to run concurrent with each other. Madam Clerk, please reflect that he has 536 days that he has previously served and imposed the standard felony court costs. Mr. Pearson, you have 30 days to appeal the legality of this court sentence. If you wish to appeal, you cannot afford an attorney. One will be appointed for you. This court is adjourned.
Your Honor, we can stay as we know.
As to remaining counts.
State would announce on all prosecutors.
Make your way to the elevator.
Can Mr. Pearson?
Come on, approach.
Yeah.
I love you, Spencer.
Thank you.